Hello and welcome to Court This Week. I'm Dina Osha. In this special editions, we bring to you top stories of legal proceedings from courts, from lower and subordinate courts to high courts and Supreme Court. We bring a selection of major legal proceedings which made headlines this week. In next half an hour, we will inform and update you of all the important proceedings from the week. So let's start Courts This Week. The Supreme Court has directed the centre to file a comprehensive affidavit highlighting all details about the smoke tower project in Delhi and why the same was not completed as per court orders. A bench comprising Justices Arun Mishra, B.R. Gavai and Krishna Murari had several questions about various aspects regarding the implementations of this project, which aims to help the national capital deal with the menace of air pollution and smoke every winter. Solicitor General Tushar Mehta was granted time till Monday, August 3rd to answer all these queries with details regarding funding, expected completions, retrieval of technology and reasons for delay amongst other aspects. Notably, when the hearing commenced today, CG Mehta informed court that the government had communicated with officials from Indian Institute of Technology, Mumbai, IIT Bombay, pursuant to which the institute would be signing a memorandum of understanding with the Central Pollution Control Board and other stakeholders. During the hearing on Wednesday, SG had informed court that IIT Bombay had decided to back out its role in overseeing the implementations of the project. The bench, through Justice Mishra, expressed great displeasure upon learning the same and stated that they would take strict actions and hinted at the drawing contempt proceedings against the institute. The bench had also questioned the seriousness of the government in seeing this project through. In December 2019, a Supreme Court bench headed by Justice Arun Mishra directed the centre and the Delhi government to ensure that a smoke towers, essentially large-scale air purifiers, was set up in the Connaught Place area of New Delhi to tackle the annual problem faced by the national capital in winter. This was to be done within 3 months as a pilot project. The Supreme Court has allowed the filing of a writ petition under Article 32 of the Constitution challenging the environmental clearance granted on June 17 for the constructions of a new parliament building as a part of the Union government's ambitious Central Vista project. A bench headed by Justice A.M. Khanvilkar told senior advocate Shyam Diwan that his client will be given a week's time to file the writ petition. The centre has to file a reply to the plea within a week of receiving the same. The matter will be considered next on August 17. In March, the Supreme Court has transferred to itself the petitions pending in Delhi High Court challenging the Central Vista project. On Wednesday, a bench of Justices A.M. Khanvilkar, Dinesh Maheshwari and Sanjeev Khanna took up pleas filed by Rajiv Suri and Lieutenant Colonel retired Anuj Srivastava against the Central Vista redevelopment project. Senior advocate Shyam Diwan argued in an intervening applications filed on behalf of private individuals carrying expertise in the field on the issue of grant of environmental clearance being granted on June 17. When arguments commenced, the bench made it clear that it shall hear the issues pertaining to the aspects of challenge to land use only as have been raised in the main batch of pleas. At this juncture, senior advocate Sanjay Hegde submitted that the clearances obtained for the parliament building were part of the Central Vista project and that there could be no change in land use in terms of the same. Ultimately, the bench said we allow a week's time to Diwan to file the petitions and the week to centre to reply within a week of receiving the pleas from Diwan. The Supreme Court has disposed of a habeas corpus petition filed for the Congress leader Saifuddin Soch after the centre told the Supreme Court in the affidavit that Soch was not under detention. The bench of Justices Arun Mishra, Vineet Saran and M.R. Shah today disposed of the pleas after the government's affidavit claimed that Soch was never placed under restraints and was always free to move. Senior counsel Abhishek Manu Sangvi sought to argue that Soch was kept under illegal house detentions. and was not allowed free movement, but the court accepted the submissions made by the government in the affidavit file. Jammu and Kashmir administration in its affidavit before the Supreme Court had maintained that senior Congress leader Saifuddin Soch is neither detained nor pulled under house arrest after the abrogations of Article 370. Rebutting the version put forth by the Soch wife Mumtaz Nisa in the top court, the Jammu and Kashmir Home Department has said the former union minister was never under any kind of restraint and that he was always free to move. Soch have been detained since August 5, 2019 when the special rights given to Kashmiri people under Article 370 was abrogated and the state of Jammu and Kashmir was reorganized into the union territories of Jammu and Kashmir and Ladakh. And Bishop Franco Mulakal has approached the Supreme Court challenging the judgment of the Kerala High Court, rejecting his plea seeking discharge him from the rape case. In his special leave petitions filed through Advocate Anand Mishra, he repeats his contention he is innocent and that he is falsely implicated after he questioned the final dealings of the victim nuns. The former bishop of the Jalandhar Diocese of Roman Catholic Church is accused of raping a nun on multiple occasions by abusing his dominant position. Allegations surfaced for the first time in July 2018 when a collective called Save Our Sisters launched public protests calling for arrest of Franco. Later, the Special Investigation Team of Kerala Police submitted a charge sheet against him for the offences punishable under Section 342, 376, 2K and 377 and 506I IPC. In his discharge plea before the trial court, the priest argued that he was falsely implicated after he questions the financial dealings of the victim nun. The trial court dismissed the plea. Challenging the trial court order, he approached the High Court by filing a revision petitions. The High Court, while dismissing his plea, observed that there are prima facie materials are available to show that the sister was subjected to sexual assault, including rape by him. Justice Circe V. has observed in her judgment dismissing the revision petition, it is not possible to infer that his bishop petitions was falsely implicated by the Mother Superior of Home functioning under him on mere enmity as contended by him. The proceeding has produced the chronicle records maintained in the home indicating his stay in the home on the relevant dates during his visits. The centre has told the Supreme Court that 4 states have not made timely payment of the salaries to the healthcare workers engaged in the battle against COVID-19. The states are Punjab, Maharashtra, Tripura and Karnataka. The centre said that this happened despite a direction from the top court. The court then asked the centre to do the needful to ensure that salaries of these workers are paid on time. The Supreme Court has issued stringent directions on June to criminalize the non-payment of dues on time to doctors and nurses. The direction has come on a doctor's petition which alleged that medical professionals were not being paid in several regions and were not provided with facilities to isolate themselves, which was a big risk to their families if they were to get infected. The centre had then declared the act of withholding salaries of doctors and nurses engaged in the battle against COVID-19 an offence under the Disaster Management Act. The order was issued by the Union Health Ministry. The Apex Court had taken serious note of the non-payment of salaries and lack of proper accommodations to doctors and said, "In war, you do not make soldiers unhappy." Top court has slammed the government for adopting a lackadaisical approach towards providing accommodations facilities to doctors and health workers at the front line of the coronavirus crisis. The court also took note of the denial and withholding of their remunerations, directing the petitioners to convey their suggestions, concerns to the Ministry of Health and Family Welfare. It has also said that the court should not be involved in the issue of non-payment of salaries to healthcare workers and that the government should settle the issue. A plea has been preferred in the Supreme Court seeking direction to scrap the inquiry commissions constituted by the Supreme Court to probe into Vikas Dubey encounter case and issued contempt proceeding against the state functionaries for the allegedly suppressing the truth behind about the members of the commission. Advocate Ghanshyam Upadhyay has filed a fresh application alleging fraud of a high magnitude practiced upon the court by all stakeholders responsible for appointing Justice B.S. Chauhan, Sashikant Agarwal, K.L. Gupta and Shri Ravinder Gaur on the judicial commissions. Upadhyay has stated that recent facts has come to light which cast aspersions on the independence of the members so appointed. As regard to K.L. Gupta, the petitions averse that he is related with the IG of the Kanpur zone, Mohit Agarwal, where the alleged encounter of Vikas Dubey took place. K.L. Gupta is related with the IG Kanpur zone, where the alleged encounter of Vikas Dubey took place and who is alleged to be involved in fake encounters and thus is bound to come under the scanners of inquiry prop. In the light of this, the plea contends that aforesaid two members of the judicial commissions are disqualified from being part of the commissions on account of conflict of interest and bias or likelihood or bias on their part. The plea goes on to state that the conduct of the state and its functionaries of concealing vital material facts which go to the very root of the matter need to be viewed seriously by the top court. This, the plea contends, make it indiscernible that the aforesaid two members are in active collusions and connivance with the state administrations. Since BJP is the ruling party in UP and Chief Minister is alleged to be involved in the fake encounters of the 6 accused and appears to have provided all support to UP government in contesting the issue pertaining to independent inquiry into Dubey's killing. The Supreme Court adjourned August 10 the hearing in the challenge to the University Grants Commission guidelines on conduct of final year university exams amid the COVID-19 pandemic. While refusing to pass interim order in the matter, the court asked the Union Ministry of Home Affairs to clarify its stance on the issue. The bench of Justice Ashok Gehlot Bhushan, R. Subhash Reddy and M.R. Shah was hearing a batch of petitions challenging the July 6 guidelines issued by the UGC to universities across India, inquiring them to complete their final year and terminal semester exams by September 30. Appearing for petitioner Yash Dubey, senior advocate Abhishek Manu Sangvi submitted that there are 16 lakh COVID-19 cases in the country at present, and that the UGC had issued its guidelines without applications of mind. He further pointed that some universities lack basic IT infrastructures to conduct the online exam. He also assailed the UGC's options of holding another exam at a later date. The bench went on to seek the response of the Maharashtra State Executive Committee formed under the Disaster Management Act. It also directed the MHA to make its stand clear on the conduct of the exams amid the pandemic. On July 30, the UGC had informed the Supreme Court that it will not alter July 6 guidelines, mandating universities across India to conduct their final year examination by September 2020. The Supreme Court has banned registration of the BS4 vehicle till further orders. Also, the Supreme Court has expressed its displeasure over the sale of these vehicles in large number during the corona lockdown in March. The Apex Court said that it suspected that a large number of these vehicles have been sold during the lockdown. The case will be heard on August 13. The court had ordered the sale of the BS4 vehicles till March 31 itself. The Supreme Court on July 8 withdrew its order on March 27 permitting the sale of the BS4 standard vehicle in the rest of the country besides Delhi NCR for 10 days after the lockdown imposed due to the coronavirus. Supreme Court had said that the automobiles vendors had violated its instructions, and during the lockdown, the last week of March and even after March 31, BS4 standard vehicles were sold. The Supreme Court also said BS4 standard vehicles sold after March 31 this year will not be registered. The bench said during the nationwide lockdown in force in the last week of March, sales of the vehicle with BS4 standard had gone up and even sold online. On the order of the Lieutenant General of India, Anil Baijal, the Delhi government has appointed 6 special public prosecutors to conduct court proceedings arising out of the 85 FIRs registered in relation to the protests against the Citizenship Amendment Act 2019 and the riots which occurred in northeast Delhi in last week of February. There are Tushar Mehta, Solicitor General, Aman Lekhi, Additional Solicitor General, Chetan Sharma, Additional Solicitor General, S.V. Raju, to Additional Solicitor General Amit Mahajan, Advocate Rajat Nair, Advocate. A notification in that regard was issued by the Home Department of Government of National Capital Territory of Delhi on July 30. The notification signed by the L.K. Gautam, Deputy Secretary of Home Department of Delhi Government, states that the same is issued with approval by the order of the Lieutenant Governor General of Delhi. The appointment of the special prosecutors in cases related to Delhi riots have been a boon of contentions between Delhi government and the Delhi LG. The peculiar situation arose as the Delhi police is reporting to the Union Ministry of Home Affairs. In February, the appearance of the Solicitor General Tushar Mehta in Delhi High Court in a case seeking investigation into Delhi riots have created a controversy after Rahul Mehra, Standing Counsel of Delhi government, objected to it by saying that appointment of prosecutors was a sole preserve of Delhi government. The objection was on the ground that LG cannot appoint prosecutors only on the aid and advice of the Delhi government. Delhi High Court has observed that almost 50% capacity of the RT-PCR tests are not being conducted by the Delhi government. While observing that despite having the capacity of conducting 11,000 RT-PCR tests per day, the Delhi government is only conducting 6,000 of such tests. The division bench of Justice Hima Kohli and Justice Subramaniam Prasad has further noted that Delhi government is more focused towards conducting the rapid antigen test despite knowing that RT-PCR is the golden test. The order had come in a writ petitions moved by Rakesh Malhotra seeking directions to be issued to the Delhi government to ramp up testing capacity in the national capital. The court perused the Sero surveillance report submitted by the National Center for Disease Control, which highlights that the highest prevalence of the virus had been found in the Shadra Central District and the Northeast District, whereas the lowest prevalence is in the Southwest District. The said report also indicates that the higher the density of population in a district, larger the number of cases of COVID-19 infection. In light of this report, NCDC informed the court that it has recommended the Delhi government to increase the testing through the RT-PCR mode for the public rather than the RAT. The court pulled up the Delhi government for not uploading the aforesaid advisory of the ICMR on its website. It ever advised the RT-PCR test, which is considered a golden test, can be replaced with RAT. The court has further directed the Delhi government, ICMR and the NCDC to file fresh status report before the next date of hearing. The court will next take up the matter on August 4th. As court continue to remain closed in the wake of the COVID-19 pandemic, more than 2,000 women lawyers from across the country have written a letter petitions to Union Home Minister Amit Shah for seeking aid for financially drained advocates. This is the first time such representation have been made by all-women lawyer group of this magnitude. The letter also calls for improvement of the infrastructural facilities for virtual courts. It was only recently that a Supreme Court bench led by Chief Justice of India S.A. Bobde took so moto cognizance of the dire conditions of lawyers across India in the pandemic. The representation to the Union Home Minister seeks the formulation of a policy so that a loan of Rs 5 lakh can be given to the lawyers to help them overcome this difficult situation. The letter adds that a policy ought to be formulated to provide infrastructural backup of all the bar associations and to make virtual hearing more user-friendly to make access to legal system convenient in this phase of national health emergency. The representation by the advocates of the Bharat status that non-inclusion of the advocates community in the schemes launched by the Union of India under the Disaster Management Act amounts to violations of right to life and livelihood of around 15 lakh advocate families. The group of 2,000 women lawyers started a signature drive on July 21, 2020. Within 40 hours or so, the number of responses on the representation crossed 2,000. The Madurai bench of the Madras High Court directed the Central Bureau of Investigation to hand over the status report on the progress in the Sathankulam custodial debt case investigation. The suo motu cases registered by the Madras High Court in the case was taken up by the evening by bench of Justices M. Satya Narayanan and P. Ramanikanam. Appearing for the state, Additional Advocate General Chelapadyan informed the court that the status report asked for in the last hearing has been submitted. The court acknowledged that it was received the same and in a sealed cover. Chelapadyan added that the CBCID had made significant progress in the case, making 10 arrests in a short span of time. Appearing for the CBI Additional Solicitor General, Karthivel told the court that a status report regarding the CBI's investigation in the case can be submitted within 10 days. During the hearing, the court was also informed that 7 of the CBI officers who had come to Tamil Nadu for the case investigation have tested positive for COVID-19 and that they are presently undergoing treatment. This apart, the hearing also saw connecting pleas being mentioned by the other counsel. The court was informed that an implementation petition have been filed in the matter by the wife of Jaya Raj, also the mother of Benedict, and also the father Sandhu, who had died in the police custody after alleged police brutality. The Gujarat High Court has made significant remark with respect to the open public access to courts hearing conducted via video conferencing. While disposing of a PIL seeking live streaming of a virtual court hearing, the bench comprised of Chief Justice Vikram Nath and Justice J.B. Pardiwala said, to observe the requirement of an open court proceedings, the members of the public should be allowed to view the court hearing conducted through video conferencing, except the proceedings order for the reasons recorded in writing to be conducted in camera. The remark was made in the petition filed by a third-year law student of Nirma University, Prithviraj Singh Zala, stating that the present system of virtual hearings, whereby the video linked to proceedings is shared only with the advocates concerned, is inaccessible to public at large, including litigants, media personnel and law students. While appreciating the petitioner's effort to raise an important issue of the larger public interest, the bench informed him that a committee of judges had already been constituted to take up the issue on the administrative side. The petitioners have argued that before the court, even in the normal parlance, physical hearings ought to be made more accessible by setting up of the live streaming mechanism in terms of the Section 327 of CRPC and Section 153B of the CPC that relate to open trials and access to public hearing during the cases before the court. Significantly, the High Court of Kerala is the only court in India which has successfully started live streaming of court hearing through Zoom app. Following the lead, a single bench of Bombay High Court has also held open for public video conferencing hearing on 9th April 2020. The Calcutta High Court has also agreed to live stream the proceeding of a case seeking entry of a children born to Parsi women and non-Parsi men into a fire temple, a Zoroastrian temple of worship in the city. However, the date for the final hearing has not yet been fixed. Resolving a decade-long deadlock between the central government and the state government, the Uttarakhand High Court on Monday issued directions for identification of a suitable locations and constructions of a permanent campus of the NIT Uttarakhand. The judgment passed by the division bench led by Chief Justice Ramesh Ramganathan come as a big relief to the students of NIT Uttarakhand, who have been the ultimate victim of bureaucratic apathy and indifference. The bench, also comprised of Justice Ramesh Chandra Kulbe, has ordered the central government to seek expert opinion and finalize a location for the constructions of the permanent campus of the NIT Uttarakhand within 4 months. In the meanwhile, it has been directed to consider the detailed project report submitted by the team of architects and engineers of the IIT Roorkee regarding the provisions of infrastructural facilities at the temporary campus of NIT Uttarakhand at Srinagar and release the funds required for the implementation thereof. A piece of land that was allotted by the state of Uttarakhand in 2013 in Sumari region of the state for NIT campus was later rejected by MHRD, Government of India, in 2016. Based on expert reports that the region was not fit to build a permanent campus for the institutions of higher learning as it was prone to landslides and earthquakes. In its judgment, the division bench has examined the scope of its powers under Article 226 of the Constitution to interfere with the expert reports and policy decision of the government vis-a-vis welfare of students. Well, that's all in courts this week. Thank you so much for tuning in. Keep watching APN and stay safe.